This is Michael Clara coming to you from Salt Lake City, Utah, with update number 16 to the Governor Spencer Cox signature list cover-up. The subtitle to this presentation is The Argument for Censure of Davis County Clerk Brian McKenzie. Here's an overview of what we will cover in this presentation. Chapter 1, the ex post on the subset of Governor Cox's candidate petitions known as flagged packets, and how we made the leap to the Davis County Clerk censure in the Utah Legislature. 2 weeks ago, I posted on X, good news, we have located all 935 of Governor Cox's signature packets. Davis County Clerk Brian McKenzie hid 21 packets and sent them to the Lieutenant Governors so she could verify her own signatures. The Utah Attorney General colluded to conceal these illegal acts. So in this presentation, we'll unpack the significance of the various subsets of Governor Cox's candidate petitions, which we often refer to as signature packets. The graphic that I displayed shows on the left the amount of signatures that we were officially told that Governor Cox had submitted with his candidate petitions, comprising of 911 signature packets. Through a series of grammar requests over the past year, we have arrived at the point where we are confident that we have identified Governor Cox's missing signature packets. Utah Politico said, I meant to write more in my comment. If they legally did this, how do we get them criminally charged? He asked Representative Trevor Lee. Can you at least censure them? After all, they've done a lot more than Natalie Cline ever did, and it's now proven and factual. Then Representative Lee replied, those that purposefully did this should be censured. So let's look at what censure is in Utah. In the Utah Legislature, the process for censure follows the same path as any other concurrent resolution. It must be passed by both the House and the Senate. Censure is used to formally and publicly express disapproval of an individual's conduct. From what I have observed over the past year, the Davis County Clerk and the Lieutenant Governor enjoy an exaggerated opinion of themselves. They understand neither reasonable limits nor morality. They feed each other's weaknesses in some kind of sick symbiosis. In this presentation, I'll put forward arguments as to how I believe the Davis County Clerk, Brian McKenzie, acted contrary to public trust and should be censured. Censure is a formal expression of disapproval by the Utah Legislature against an elected official for actions deemed unethical, immoral, or contrary to public trust. Unlike impeachment, which requires a House investigation, articles of impeachment in a Senate trial for removal from office, censure is symbolic, non-binding, and does not remove the official from their position. It serves to publicly condemn behavior and set a precedent, as seen in the historic 2024 censure of Utah State of Education member Natalie Cline. This was the first such action in Utah legislative history. So let's go over to Chapter 2, the candidate petition and signature verification process. This will be a quick review for many of you, but it'll serve as a much-needed context to this presentation. So the Cox-Henderson campaign, as candidates, petitions were submitted, given to gather in ink, the blank ones, and then those petitions are then submitted to the Davis County Clerk once the signatures are collected. On February 20th, 2024, Governor Cox declared on X that he reached the 28,000 signature threshold, allowing his campaign to submit their first batch of signatures to the Davis County Clerk. A month later, the Davis County Clerk declared that the Cox-Henderson campaign had reached the threshold of 28,000 signatures. From the inception of this debacle to the present day, there seems to be no argument as to what the process is for verifying signatures. Here's a June 19th, 2024 email that Ryan Calley, who is the state election director, sent to Natalie Clausen, who at the time was the candidate for lieutenant governor. And he explains right here in no uncertain terms that the process for verifying signatures is outlined in code. See Utah Code 28-1-1002. And basically what that says is that you verify signatures in this order. So when the county clerk receives a signature packet, they enter that information into the what we call the VISTA database. And because once you start entering names or you start plugging in names or typing names, it'll bring them up in the VISTA database because that's where all the voters' information is at. And the first thing is you verify the name, verify the address, verify the age, are they registered to vote, registered under the correct party affiliation, because only Republicans could submit signatures or be verified as valid signatures for Governor Cox. They had to be Republicans, living at the correct district, which would be statewide. Then you do the validation of the actual signature. Along with that definition of how to process signatures would be what are called unviewed signatures. And here Calley explains it in that same email. He says the Cox-Henderson campaign submitted 592 additional signatures that were not verified once a required 28,000 signature threshold was met. And that's pretty self-explanatory, and it's consistent. Even through the audits that happened last year, it was consistent as to what constituted unviewed signatures. So this is the one category, we'll identify throughout this presentation, which would be unviewed packets. Let's go on to Chapter 2. What are the flag packets? And in October of 2024, we had an audit that was presented to the audit committee in the state legislature titled Signature Verification Process. And what they tell us here is that there are formal processes in place to qualify or disqualify candidates from the ballot. This audit is not part of those official processes. So in this audit is the first time we get an indication that there was a problem, that the process was not followed. And they tell us here that the numbers in this figure do not include the signatures and packets that were submitted to the Office of the Attorney General for further review. The Davis County Clerk's Office completely removed those packets and signatures from the count of submitted and reviewed signatures for each candidate. So I can't emphasize enough, that is not the process. And then they tell us down here, in these instances, the Davis County Clerk office removed the packet from the verification process and sent it to the Lieutenant Governor's office. The Lieutenant Governor's office then reviewed the packet and determined whether to send it to the Office of the Attorney General for further review. Again, that's not the process. And let me just show you to the present day. Remember I said that since this debacle started, everybody's been consistent as to the process. I just got this a few weeks ago from the attorney in Davis County, who's the attorney for the Davis County Clerk. He's responding to a grandma appeal, and he says right here, he says to qualify for a primary ballot in a statewide race, 28,000 valid signatures are required and are validated in accordance with Utah Code 28-1-1002. And the laws that he's quoting here is, again, the same one that I already brought up. There is one exception, though, that if you're going to reject packets, there's a rule that explains how to do that. If the filing officer rejects a submission, the filing officer shall provide the candidate with a written explanation of the rejection. And so I submitted a grammar request for this back in February this year. I am requesting all rejection records in reference to candidate Spencer Cox signature submissions for the 2024 election cycle. It says here, Our office has not, this is the Lieutenant Governor responding to my records request, our office has not issued any notices of rejection for any of Spencer Cox's nomination petitions. We have also contacted Davis County, who received and performed the verification of all statewide nomination petitions and have confirmed they did not issue any notices of rejection for the Spencer Cox nomination petition submission. As a result, there are no records responsive to your request. All right, so that's the process. So the other thing I want to point out that we learned from the Office of the Legislative Auditor General is that there is an investigation going on. He says that the numbers in this figure do not include the signatures and packets that were submitted to the Office of the Attorney General. This was an interesting revelation because up until that time, we had, let's connect the dots here, that in July and August, these two guys with the Attorney General's office, this is Lonnie Pearson, is now the director of records. So if you have an appeal, he's now the one that was appointed by the governor earlier this year to now hear record appeals. But last year he lied when he worked for, he's lied on several occasions. I'm just pointing this one out. In response to my grammar request for the investigation into Governor Cox's signature list, he said it doesn't exist. And so the current Utah Attorney General's office has descended into what I would call just an inbred of arrogance and political abuse of power. And the narcissists who possess the authority of that office have demonstrated a disregard for the rule of law. Daniel Burton's the other one. He's the one that, in my appeal, said there is no investigation into Governor Cox's signature list. So to that end, I did get a copy of the report initially through a whistleblower that gave me the entire 200-page report. And what we learned from there is all the signature packets for Governor Cox that are in this flagged packet category, we know what they are. We know their dates. We know the numbers that was assigned to them. We know how many signatures they have and which ones were validated and which ones were not. So this is what it ends up looking like, is the flagged packets. And you see here, we know what dates they were turned in, or at least we know what dates the signatures were collected and when they probably should have been turned in. Here's the problem when I say that these flagged packets are illegal, because we know they're not part of the unviewed category, but here's the problem they run into. And this is coming now from the attorney of the Davis County Clerk. And this was from a couple weeks ago in response to a grammar appeal. He's going to explain to me, because remember, he says, well, I might not understand the process. So he's going to explain it to me. So here he says that in the lieutenant governor's race in a state of Utah for 2022 candidate, in the manual, it says that they're advised that prospective candidates that regardless of your petition size and submission date, election officials will complete the verification of your petition within 14 days after the signatures are submitted. And he says that this is from the manual, okay? And it's right here. He's right. And he goes on to quote the law. He says, also see in the election code 20A-9-403, signatures will be verified on nomination petitions in a transparent and orderly manner, no later than 14 days after the day of which they are received. And this is the law. It's to provide a transparent and orderly manner for these signatures to be verified. So you see the problem here. When you line up the dates that we now have as to when they were turned in, these were not processed within 14 days. They weren't rejected according to the law. And because there's no submission forms or rejection forms that were issued by the Davis County Clerk. So this is why I say you end up with these signatures or packets that essentially are illegal, because they're not part of the process that was established by the legislature. Through subsequent grammar requests, I find out there's only 380 unviewed signatures. So what I know today is that of the unviewed packets, there's 15 packets on the unviewed signatures, and that's because those were the ones that were turned in on the last day that Governor Cox turned in signature packets, and as he reached the threshold at 911, 911 is a packet number. They all have numbers, so he had turned in 911 at that point, reached the threshold, they stopped counting. And what was left over were 15 packets. So over here on the left, we have the 21 flag packets. So according to the audit that happened in October, OLAG says this is how they're defining them. That packets that the Davis County Clerk's office did not review because the candidate already reached the required number of validated signatures. That's the unviewed packets. And then there's the packets that the Davis County Clerk's office flagged for having many non-matching signatures and were subsequently sent to the Attorney General's office. So for our purposes, those are the two definitions. Let's go into Chapter 3 in the legislature. So here's the law that I believe that Brian McKenzie has violated, and I'll go over that in this section, that obstructing a legislative proceeding. That when a person makes a false material statement, not under oath, but does make this to the legislature or a committee or subcommittee. So let's start back in October 15, 2024. In that audit subcommittee, Davis County Clerk McKenzie speaks extensively about the Davis County clerks being certified and trained to conduct the signature verification. That turns out not to be true. I've covered it in previous updates, and he also references the contract that the Davis County clerks that he had with the lieutenant governor. We'll cover that also. So, like I said, none of his deputy clerks and even himself were certified to be conducting the signature verification when they did. As you can see here, through grammar requests, I got all of their certifications that were all incomplete. OLAG says that the office of the lieutenant governor is the filing officer over statewide races. It is chosen to contract with the Davis County Clerk's office to verify signatures on statewide races. Even prior to OLAG bringing that up in October, back in July of last year, this is what Scott Cheney was saying to the court when he's fighting that grandma appeal by Phil Lyman. He says for candidates seeking statewide office, the lieutenant governor's office contracts with the Davis County clerk to verify signatures because the Davis County clerk's office has, he says, to avoid conflicts of interest. All right, here we go. Let's go back and listen to this. This is from May 22nd of this year to the Oversight Committee. This is what Ryan Calley said.
You've had the audit, and I figure, maybe a best place to go is talking about changes you're making to your processes to implement things that were learned in the audit and how that's going, I guess.
Yeah, thank you. I assume you want me to go first, Mr. Chair?
Yeah, go ahead.
All right. I'm Ryan Calley. I'm the Director of Elections in the Lieutenant Governor's Office. This audit was very helpful. It was one of 4 audits that were conducted over the signature verification process, too, by the State Auditor's Office. OLAG performed this audit, as well as one that was over the privacy and how the privacy of signature verification nomination petition packets was handled. So we appreciate the opportunity. Obviously, there's room for improvement like any process that we have. Since 2014, the Lieutenant Governor's Office has contracted with the Davis County Clerk to perform this. One thing it does do is create that independence, so the Lieutenant Governor isn't verifying packets in a race where she is potentially a candidate or a running mate. It also allows the clerks do signature verification all the time. The Lieutenant Governor's Office doesn't. They have the space, they have the means, they have the capacity, and so that's been a really good relationship.
So there you have it. The reality of it is when the Davis County Clerk verified Governor Cox's signature, there was no contract in place. And these guys, why call it, it's actually incompetence, camouflaging corruption. I'm not going to speculate as to why they made sure this no contract was in place, but just understand there wasn't one. Here's the email exchange where there. After Governor Cox's signatures are all certified or verified, it's like, oh, let's get the contract signed. So here they sign it 2 days after Governor Cox's signatures were verified. Let's go back and listen to what McKenzie has to say to the Oversight Committee about the flag packets.
Okay. You mentioned that in that process or in that question, when the statewide races, when there's a concern about signatures or whatever, you forward them to the lieutenant governor's office when they're the election officer. But that would include elections that the lieutenant governor might be involved in, right?
Currently, yes.
Yeah.
Yep.
Which might create a conflict or a weird, perception. I mean, ideally, I'll step back here just real quickly, just from a philosophical standpoint for me. Ideally, we want to communicate to the public as much as we can, that they're in the elections process, especially that, the government is calling balls and strikes, but not necessarily stacking the team, And I think the hardest part is when there's a perception that we're stacking the team, even if it's true or not, right? We get questioned, and there are frustrations that arise as a result of it, right? And so my fear is that as long as our process has the ability to create conflict, then, and we know it's built in there, that we have problems, right? Ryan, how do you guys deal with that if the county clerk, sends things that, they have questions about a signature packet or whatever it may be, or incidents of fraud in the signature process? How do you guys deal with that?
Yeah, the way we dealt with it this past year is we just did a preliminary review. We do have about 75 years of election experience in the LG's office, which is kind of a newer trend. We just reviewed the packets that the clerk gave us, and actually all of those were referred over to the AG's office for investigation. Policy considerations there.
Okay. Yeah,
Mr. Chair.
That makes sense. Yeah.
If I may provide some clarification.
Please. Yeah, I agree.
Just some additional information on those packets that are forwarded. It is important to note that the Lieutenant Governor's office did not take on the role at that point to verify those signatures.
Right.
That remained under our responsibility. So, but I think you do.
Earlier this year, in responding to a Graham appeal, it's Cheney that says that, as noted above, certain and unviewed, uncounted signature packets from Cox campaign were delivered to the Attorney General's office for investigation regarding potential fraudulent signatures. And he says that they were not verified by the Davis County Clerk. And he says it again in a different response to a Graham appeal a couple of months ago. He says the clerk sent those packets unreviewed and unverified to the office of the Lieutenant Governor. As if that's not enough to go against what we just heard Ryan Cowley tell the legislature in this report that these idiots claimed didn't exist. This is what we learn about that. On May 29, 2024, this is Investigator Jordan says, I met with Ryan Cowley and Daniel Wade at the office of the Lieutenant Governor. And she says that here that Cowley, she says here that Cowley explains to her how this VISTA system works. Then down here, during our interview, Wade advised he had reviewed parts of the circulator petitions and identified some indicators of fraud. I provided Wade with the accordion file, and she says Wade advised he would contact me once he'd examined every signature. She says on July 1st, 2024, I received the circulator petition packets back from the Lieutenant Governor's office, and that it was Daniel Wade, the election assistant specialist, had been in the process of verifying and running every signature and all the packets through their VISTA system. And that he did each packet, had a cover sheet, and Wade had created, and he indicated each signature was a match, no match, unreadable. And in total, there are 48 circulator petitions Wade verified. and then I showed you what it looks like once he did it. The important thing to understand here is this is the lieutenant governor verifying her own signatures, which they claimed never happened. Then on September 11, in her report, she says that these packets were never validated by the Davis County Clerk's office. With that, I had Daniel Wade, the election assistant specialist with the Lieutenant Governor's office, conduct a validation on the packets. And then she gives us the numbers of what came of those for that particular offense report. So here's the dilemma, is that you have this breach of trust that's going on by Brian McKenzie. Now, there's a chance that Cheney, who represents the lieutenant governor in court and in responses to my grandma appeals, is lying. There's a chance that Jordan, the special agent with the AG's office, is lying, and McKenzie's the only one telling the truth, along with Callie. But my money is on that these two guys are the ones that lied to the legislature. Let's listen to another exchange that I had with them at this same May 22nd Oversight Committee hearing earlier this year.
What I could determine through grandma is that these packets that they sent to the lieutenant governor, that the clerk sees them, sends them to the lieutenant governor, and when they got to the process where they get through the threshold of signatures, they realize that Governor Cox is short signatures. They returned flagged packets from the lieutenant governor's office back to the county clerk, and the county clerk harvested signatures from those flagged packets that were supposedly bad.
All right, so just to keep your bearings, remember the definitions of flagged packets versus unviewed packets that we get from OLAG. Now listen to what McKenzie says in response to me saying, well, I think that you got signatures out of these flagged packets. They came back and were used in the unviewed packets section.
And Lieutenant Governor's office, come back up real quick, give you guys a chance to respond to some of those things. And then I have a few questions for you myself, and then we might get out of here before 11:30. We'll see.
All right. Again, Brian McKenzie, Davis County Clerk. I think it would be fair for me to say that there's a number of things that were presented during those public comments that I disagree with. Some of those are based upon opinion, and that's okay, but some of the things that were shared were blatantly false. Number one, flagged petitions that were considered for fraud investigation were never delivered to the LG's office and then returned to my office during the verification process. I don't know where that data comes from. It's false. I'm concerned that it suggests that there would be a criminal act in that case, that we nefariously were working in coordination with the Lieutenant Governor to try to find more signatures to.
All right, so let's go back to this offense report that they claimed didn't exist, but it does exist. And this is what we learned, that on August 29, 2024, the agent says that she was notified that the state auditor was conducting an audit related to signature ballots. And she says at 4:00 p.m., Daniel Wade with the Lieutenant Governor's office and John Dougal with the Utah State Auditor arrived. She says she opened up the packets and that Mr. Dougal requested to view packets 1305, 1324, and 1736. I handled each packet while he conducted his audit. Once the audit steps were complete, he left and I resealed them. Now, in these three packets, there ends up being, I think, something like, I'd have to go look, but I think it's 43 signatures are valid for Governor Cox, and they use those. How they use those still remains to be seen. That's what this grandma appeal was about. I want to see which of these flagged packets that they end up converting into unviewed packets, or use the signatures to help Governor Cox meet the threshold. We don't know because they won't reveal them. But suffice it to say that here you have the state auditor and the lieutenant governor hiking it back to go harvest signatures from these unflagged packets. What's telling about that is that when Dougal submitted the conclusions of his audit back in September, he is pretty clear that the validators that did those verifications of those spare signatures are the Davis County clerks. He doesn't say anything about the lieutenant governor's people actually validating these signatures, that he's now going to call them spare signatures. This is the problem. So going back to this offense report on September 3rd, while conducting an investigation for case AG 24320, she says she goes to the Davis County Clerk's office, and the Davis County Clerk Brian McKenzie advised they had received more packets Benson had turned in. However, Brian stated that these packets had never been validated or counted in an official capacity. Brian said the packets had only been validated for purposes of the state audit that was being conducted. Brian said that when the packets get validated, they are validated in Reading. For this particular circumstance, the Davis County Clerk's Office validated Benson's packets in green. All right. So here again is another instance of, they're going to count these as unviewed because they're using them in the state audit. So now this is the second set of flagged packets that we now see are going to be used to count towards Governor Cox. Now, shift gear, put that on pause for a second, what we just learned. All right, we'll come back to that. So what happens is, because I'm giving you this in chronological order as it unfolds in this offense report. So remember, just keep in mind that this was on September 3rd that he's telling her about these packets that apparently nobody knew about, but he did. So here we go. The following day, the OLAG auditors show up. And she says that once the auditors, and it was 4 of them, arrived, we were told they only wanted to review Cox, Brown, and Curtis signature packets. The 4 auditors were identified, and she gives us their names. The auditors had not touched the documents during the review. The agent assisting the auditors handled the packets of signatures. The auditors wanted to review the signature pages for their own purposes, which was not shared with us as a group. And interestingly enough, the chief of staff, Cantrell, is there. I don't know what that's about. But at least in this case, in this audit that the OLAG released, they tell us that they did this. We reviewed concerning packets in the custody of the Office of the Attorney General as part of our audit process. So all they're doing is just looking to make sure, and I don't know if they explained that in here or I saw that in the email, that they were just making sure, I think they do talk about in their audit, to make sure that, it's not like obvious that something's wrong with them, which I think the obvious part was that the signatures were all forged and written by the same person, but they wanted to make sure there's no photocopies and things of that nature. So, but at least they tell us they looked at these flagged packets. We don't get any indication of that from John Dougal. In fact, John Dougal lies to us. He tells us that those were all validated by the validators, which were the Davis County clerks, and that ends up not being true. As you saw, it was actually the lieutenant governor that validated those signatures. So moving on, let's go back to those green packets, or the ones that I identified as these packets that are in green ink or were checked in green ink. Now on the 10th is when the Attorney General's office is going to go back to the clerk's office to retrieve them. However, when the investigator from the Attorney General's office arrives at the Davis County clerk, she runs into a lieutenant governor representative again. And now this lieutenant governor representative is the one that has possession of these three mysterious packets that McKenzie just, in my opinion, just created out of thin air, because there's no reason, you can't even account for, how these got there. Other than we're told that they all have Davis County Clerk stamp on them that they were received on March 15th, 2024. If that's the case, then those should have just been unviewed packets. But and if they were unviewed packets, they would have taken a different course they would have been produced. But anyways, they end up not even fitting into either category here. Also understand that the four OLAG auditors, they don't see these because they went to the Attorney General's office to view the packets that were with the Attorney General, but for whatever reason, between the Attorney General, investigator, and McKenzie, they decided that OLAG didn't need to see those, so those stayed with Brian McKenzie, and after OLAG goes to the Attorney General to see packets, then they're going to go ahead and put these into the mix at the Attorney General's office, which is very bizarre. The other thing I want to point out, let's just quickly go over what we can glean from audits and different responses to grammar requests. We know that in this audit, about how packets were handled. We were told that the Lieutenant Governor's office did not obtain possession of the packets until after the Davis County Clerk's office had finished its verification process. So what I'm saying is that if this is true, then those three green packets should have been in this bunch, and McKenzie wouldn't have had them. Same thing here. We have Cheney, who's the attorney for the Lieutenant Governor, says at the time of this determination, the clerk's office stopped processing Cox campaign signature packets. And at this time, all of the additional excessive signature packets were transferred to the office of the Lieutenant Governor. Again, we're told that these flagged packets were all given to the Lieutenant Governor. So there's no reason, again, for McKenzie to have had them. And then he says that were flagged, that certain circulators were flagged for potential fraudulent signatures and sent to the office of the Lieutenant Governor. After receiving the flagged packets, OLAG transferred the packets to the office of the Attorney General for investigation. Again, these lost three packets. In the event that there's any question about, but here is his attorney told me a couple weeks ago that following the additional signature review, this is about the September audit from the state auditor, the petition packets containing the original signatures were delivered to the custody of the Lieutenant Governor's office. So again, there's in all these explanations as to how these packets move back and forth, there's no explanation that were given as to why McKenzie would end up with three additional packets out of nowhere. But we do know that they go back to the Lieutenant Governor and they're counted, which is what he tells the committee, no, that never happened. And again, so that's another one of his lies. These packets actually were moving back and forth between these three agencies, and that's not the law. That's not what the legislature intended would happen. Let's move on to Chapter 4 with the unviewed signatures. We're going to go into what happened at the courts. Here is a state law that says that making a written false statement, an actor commits making a written false statement if the actor makes a statement that the actor does not believe to be true, with the intent to deceive a public servant in the performance of the public servant's official function, makes a written and false statement that the actor does not believe to be true. So what happens is on this, as I covered in update number 15, when this court case gets filed by Lyman he wants to see, it's a grandma appeal, he wants to see all of Governor Cox's signature packets because he suspects something is wrong. Cheney, representing the Lieutenant Governor, files the motion in opposition to the Lyman being able to do that. In his motion of opposition, Cheney files this Exhibit B, which is a statement by a written statement by Brian McKenzie. And Brian McKenzie, this is what the statement is. I've highlighted in yellow all the things that I could identify that are absolutely not true. Persons that collected signatures, they had met the statutory requirement. The statutory requirement is that you're 18 years of age and that you're a resident of Utah. But here's an email I came across through grammar requests that says that you have Shelley Jackson again with the Lieutenant Governor's office telling the Walton campaign that during our most recent legislative session, the requirement for Utah residency has been dropped. That's a lie. That she sends this email March 19th. We didn't change that law until this session this year in 2025. But last year, that the law, and she actually quotes the law here, by the way. She says right here in 28.9 408, when you look that up last year, it says that you have to be a Utah resident in order to collect signatures. And if you fill out the circulator verification form, it says right here, you declare it. I am a Utah resident and I am at least 18 years of age. And you see, so when I did a grammar request for the Cox circulators that I could figure out through open source research that they were not residents of Utah, Colton Drake was one of them, but of course they redact his address, so I can't see that. But and he had an indictment for forged signatures. He's a citizen of the state of Washington, and I already had figured that out before I saw the indictment. But here's confirmation of that. In the handbook for candidates, it says here that you have to be a resident. And if they find out you're not a resident, a circulator does not meet these requirements, the signatures they gathered are not valid. Well, they're not going to do that because Colton Drake, he had valid signatures that he turned, as others did, that are not residents. They had turned in valid signatures for Governor Cox, and as you can see, a lot of them are private anyways. So that's another lie that McKenzie tells us. Just to connect the dots here, remember back in July 18, 2024, that Natalie Clausen wanted to see the Ipsen list because she felt that she could find some of these discrepancies that it took me a year to find, but they didn't give us the Ipsen list, so we couldn't compare those signature gatherers to what they collected to what they turned in for Governor Cox. By the way, let's look at this. These are 5. Remember, there were 11 charged. 5 of them were working for Gathering Inc. That's a company that Governor Cox used, and that's a company that Ipsen used. Only one of them was charged with forged signatures on Governor Cox's petitions, and that's Benson Angulau. And those are what we've been looking at, constitute the flagged packets. The forged signatures that these other ones turned in for Governor Cox, they were not prosecuted for that. They were only prosecuted for the signatures they turned in for Ipsen, and there's a good reason for that. So, but I want to show you here that one of the other problems, that's one of the reasons why I think they didn't charge them for forged signatures and the Cox for the Cox packets, is because in their indictment, again, they're only getting indicted for forged signatures they turned in for Ipsen. They say that their signature packets contain 5 pages for voters to write their names, addresses, and ages and signatures. The cover sheet of the packet included a candidate name, and then there's a last sheet, which is a verification form. But understand there's only 5 pages they're saying for signatures, which is 10 each. So you can't get more than 50 per packet. And there's other documentation I have to confirm that's exactly how Gathering Inc. was passing out packets to the signature gatherers. But on Cox's list, we end up with signature packets that have like over 50. This one has 197, and it's submitted by Colton Drake. And you can see here that there's more staples. And I only got the cover sheet and the back verification sheet for these. I'm not looking at the whole packet, but I can see here that there's staples put in here that have to bind them all together. Some of these staples, and by the way, the people that turn in inflated signature package for Governor Cox are the ones that are indicted for forged signatures for Ipsen. So what I believe is what they did is, because you can see here, and some of the others are even worse, when you can see the staples, it would have been difficult to open these up to have people sign them. So I think the clerks did this, because what are the odds that the ones that have inflated signatures above 50 are the ones that turned in forged signatures for Ipsen? And you can see here's the indictments for the ones that turned in for Ipsen's. They all say this, that the packets all contained for Senator Ipsen 5 pages, but somehow for Governor Cox. And here's one, Joseph Wild, the one I just read, the indictment, 230 signatures. So anyways, that's one of the other discrepancies. Oh, and by the way, remember McKenzie tells us that all these candidate petitions were date stamped. He that's in his written statement to the court. That's not true. These, especially these ones with inflated signatures in them above 50, they're not date stamped. So this is what it looks like when it's date stamped. It shows that the county clerk received this on this particular day. They date stamp it. And this is packet number 910. That's the second to last packet that was turned in for Governor Cox and date stamped on this day. And that's what it looks like. And again, no date stamp. And any suspicious packets. And this is why you have a date stamp. So that we can make sure, that this is one of the control measures. But again, that turns out to be a lie. These packets were not all date stamped. So just going back to this timeline in the court case, what ends up happening is that back in last year, that once the lieutenant governor signs a certification for the election results of the primary, the law says that you have 10 days to contest the results of the primary. Had Lyman been given the evidence that he was asking for, wanting to review those signature packets, he would have had time to contest the outcome of the primary election. But because they withheld that information, he couldn't do anything with the results of the primary election by law. This is what they were hiding. Now, there was a third audit that was done that we didn't know about until a few months ago because Tina Cannon told us about it. But her predecessor, John Dougal, did a third audit and kept it secret. But in that third audit, they looked at every signature. And as Tina Cannon revealed, she doesn't give candidate names. They have codes. I think this is the one that would have been candidate Cox. And he has 1,328 signatures that were deemed valid by the Davis County Clerk, but which the CPAs that examine these believe that these were not valid. They shouldn't have been validated. Understand, these are validated signatures. These auditors didn't look at the signature packets that were with the Attorney General. They looked at the signature packets and looked at the ones that were valid, and they're saying that you could just tell that they were forgeries. You could just look on the same page and see that they were either one or two were forged because the same person signed for the family member, or that somebody signed signatures on the same page. And that's before even looking and comparing them in Vista. I believe that is what they were trying to hide from Lyman, but they actually did this audit in anticipation as an insurance policy, if you will, in the event that Lyman won his case and was able to see the packets, he would have seen these forgeries that these guys talk about, but they would have produced this third audit to say, hey, we already know about him. But because Lyman's case was dismissed, they buried this audit. And again, the reason I'm bringing this up now is because McKenzie was aware of all this, and they had to cover for McKenzie. So going back to this court case, when he's talking now with the backdrop that I just laid out, when Cheney is representing the lieutenant governor in court last year, this is in July, he's saying that there's 600 signatures that were unverified. And he says that they were in possession of 600 additional signatures that they did not check. That's a lie. That was a lie to the court. 36% of those signatures have been verified. And the reason I know that is because up to this day, I can only get account for, or they can only account for 380 signatures in this unviewed. If he had 592 total, then 36 of those were verified by the lieutenant governor. She verified her own signatures, and she got them out of this flagged packet category. That should have been disclosed to the judge, because remember, by July 1st, they knew this. By July 17th, when Cheney's over there in court trying to get things dismissed, he lied to the judge. Had he told the judge that of these unviewed signatures, 36 of them were verified by the lieutenant governor, the judge, I'm certain, would have said, that's not right. That doesn't follow the process. You got to give these packets and let Lyman see it. Something's up here. But because they lied about, the information they were presenting in court, that's how they got away with it. And McKenzie, again, is at the center of all this. In closing here, let me show you here this article that came out. It says, this is following Dougal's audit. Utah auditor, is statistically likely that Governor Cox and others qualified for the primary via signatures. And here you have Lieutenant Governor saying, we are pleased with the audit report on the signature verification procedures for candidate petitions. This independent review confirms that our office has never doubted that the Davis County Clerk's office performed their duties well, and that processes and laws were followed. She says, while continuing to cast doubt on election results without evidence, Lyman has previously called for, okay, first of all, let me just say without evidence, right? You have the evidence. You're the one that in court during this whole year of 2024, in September when this article is written, she's being quoted, they're fighting in court to make sure Lyman doesn't get the evidence. And in this playbook, Erosion of Accountability, I added this, it's called the Russ Rampton tactic, because this is one of the surrogates that was just rabid about defending Governor Cox and the Lieutenant Governor on X. He's kind of faded away and doesn't do it anymore because I think he realized how foolish he looked. But at one point, at his height of being rabid about them, he would say, well, that's not enough evidence. So if I had evidence of wrongdoing, he would want more evidence. But of course, I would say, well, but how would I get the evidence if the lieutenant governor is the one that's hiding it? And if you want evidence, go to her. You're working for her, so have her give you the evidence. Don't come hound me about it. But that's exactly what she does here. She says that she's gaslighting Lyman while continuing to cast doubt on election results without evidence. The other thing she does in gaslighting Phil Lyman is she points out here that he doesn't, well, let me start it here. Back in June, Lyman is calling for an independent audit. Lyman called for an outside group, preferably a CPA firm, to review the signatures, and he says that an independent third-party verification is needed. The fact that the lieutenant governor's office won't do it under any circumstances is very telling. There's no transparency, he says. In that same article, you have McKenzie saying, no, you can't do a third audit. He says that he does not believe a signature review by an accounting firm is possible under Utah law. As it relates to additional reviews, I'm not aware that there's anything in the law that would allow for that. Yeah, you better hope not. Here again, you have the lieutenant governor, because her and McKenzie do this 1-2 punch all the time. She says that without evidence, that Lyman has previously called for more than an election audit conducted by the auditor's office, but rather an external, independent, third-party audit of our elections. Guess what? So she says this in September, that within a week, they actually started a third-party audit, but doesn't tell anybody. And recently, through a grammar request, an ex-user sent this over to me. They got this. It's $344,000 that the state auditor is billing the attorney general for reimbursement because they hired 2 outside CPA firms, and they did a third audit. And they're the ones that concluded that Governor Cox has 1,000+ signatures that were verified that should not have been by the Davis County Clerk. So my point is, this is the kind of money that we're spending. And then they try to bury this audit. This is how much it costs. All for Brian McKenzie to cover up his lies or to use as an insurance policy had Phil Lyman won his case. And of course, they're gaslighting Phil Lyman the whole time, a third audit and mocking him when they actually did it. They actually followed his advice. This is why I get so frustrated and why I'm calling out the leadership of the Utah Republican Party. These guys are just incredible. They're part of the problem. I can present evidence that shows that wrongdoing is being done. Yet these guys are going to say in the September State Central Committee meeting, and you guys know the story on this, they cut this part out of a resolution because it's a federal court case that Lyman is pushing or transparency in our election records. And these guys on the Utah GOP leadership don't want anything to do with it because they're done with Phil Lyman is what they said, which is just ridiculous because Phil Lyman's not the problem here, but somehow they want to make him the problem because they want to align themselves with the corrupt attorney general. And so that's just, the Utah culture. We're going to have a hard time. We've normalized election fraud, and it's embedded with our leadership. So here's the order. I just want to show you this, that in December of 2024, Lyman's case was dismissed. This is the one to see Governor Cox's signature package, and his case is dismissed based on lies that were being given to the judge by the lieutenant governor and the attorney general. But as you see here, one of the things the judge says is that we can't have voting records disseminated to third parties. And so, but here's the problem. When Gathering Inc. gets their election records from this company called L2 gets them from the lieutenant governor, and all the voters are on there, all of them, even the private ones. That's how Gathering Inc. can go get see all the voters, even the private ones. The other problem that I'm having is that we see now that the lieutenant governor will give all the information to third parties, to CPA firms to do audits on all the voters. So everybody can see all the people that signed before and after, but you're not going to let Phil Lyman and Natalie Clausen see them. You know why? Because they'll detect that there was fraud going on, and they'll have the evidence. We already have the evidence. The problem is it's too late to contest the election, and that was their purpose, and delaying giving that information. So let me just conclude here that there in our executive branch here in the state of Utah, we have like an attorney general, a lieutenant governor's office that's just way too political, incestuous, and self-serving, and self-institutionalized to even acknowledge that there's election fraud. So we have to, again, lean on the Utah Legislature and get more of their help. They passed a couple of laws this session that's going to hamper the lieutenant governor's ability and the likes of Brian McKenzie to cheat in the next election. But there's also laws that we didn't pass that we actually need to work towards passing. And I'll talk about those in another update. For now, since the Attorney General's office has abandoned or abdicated, I should say, their responsibility regarding violations of election laws by the Lieutenant Governor and the Davis County Clerk, again, unfortunately, I'm sorry to say, we have to demand the legislative branch of government to take action and call for a censure. And if you live in Davis County, I recommend you start a change.org petition or some other kind of petition to ask the legislature to censure the Davis County Clerk for his breach of public trust. So what elected officials do with the power that they enjoy reveals a lot about who they are. We know that our legislature will condemn and censure a state school board member for one social media post. My question is, are they going to be just as passionate about a litany of election fraud that can be laid out that was committed by one person, by the Davis County Clerk Brian McKenzie? So I think it was George Orwell that says, "A people that elect corrupt politicians, imposters, thieves, and traitors are not victims, but accomplices."